We are very lucky to have with us live in the studios this morning David Gespass. David Gespass, for the past 25 years, has maintained a general practice in Birmingham, Alabama. He is the current president of the National Lawyers Guild and has previously served as the NLG Southern Regional Vice President. He has also served for 4 years on the editorial board of the Guild Practitioner, the Guild's theoretical journal from 2004 to 2009, in the position of editor-in-chief. And he has been a member of the National Police Accountability Project Advisory Board since its founding in 1999. So to start out, tell us about the National Lawyers Guild.
The Guild was formed in 1937 in opposition, actually, to the American Bar Association, which back then did not allow African-American members. So the Guild was the first integrated national bar association in the United States. And it was also formed because the ABA back then was very much opposed to the New Deal and New Deal legislation. So the Guild was formed to support that, and by and large by union side labor lawyers and government lawyers in the Roosevelt administration to promote labor rights and also to advance the New Deal. In the early 50s, during the McCarthy era, it got really decimated. It lost the vast majority of its membership because we were the only organization in the country that defended real communists. The ACLU, for example, had its own loyalty oath that it imposed before deciding whether to defend people who it found wrongly accused of being communists, and that was also the time when Elizabeth Gurley Flynn was removed from the ACLU and its board because of her communist affiliation. And it was actually, the Guild was attempted to be placed on the Attorney General's list of subversive organizations, but we did have lawyers, so we were able to overcome that. And then back when I joined in 1969, when I was in law school, and from a few years before that, we kind of revived, first by supporting the civil rights movement in the South. We sent a group down there during Mississippi Freedom Summer to assist. And then during the anti-Vietnam War period, we grew a great deal again. And since that time, the Guild has really been involved with support of all the progressive struggles that have gone on in the country. These days, even more so, international work has become an important part of our work because the world is getting smaller, if not flat, and whatever we do here in this country has such a huge impact on the rest of the world, even leaving aside illegal invasions of countries here and there around the world. And so our international work has become really important. We have very good relations, for instance, with the Venezuelan government and the Cuban government. We were actively involved in the first South African elections. We've sent a number of delegations around the world. I think, did a very good job. I was fortunate to work on a delegation that went to Pakistan during the lawyers' movement there. And the work we did when we came back, by a couple of the people on the delegation in particular, really, I think, had an impact on U.S. policy and had a role in the removal of Musharraf from the government and creating at least a somewhat imperfect but still more democratic society in Pakistan. And I also mentioned, by the way, the Guild was the one non-governmental organization that was invited to participate in the founding of the United Nations in San Francisco.
All right. And do you have to be a lawyer to join the Guild?
No. The Guild membership is open to law students. That was in our convention in 1970. It was my first convention when I was a law student in Washington. And we voted then to admit law students as full members of the organization. And a couple of years later, in 71, in Boulder, Colorado, we voted to admit legal workers and jailhouse lawyers as full members of the organization. And that was interesting because back then, virtually all the lawyers in the country and in our organization were men, and the legal workers who worked in our offices and were very active politically were women. So it was not simply a matter of adding to our membership legal workers because of the work they were doing, but it was also part of the women's movement back then. And the issue of sex discrimination within the organization, because, again, if we limited our membership to lawyers, we limited it to men. That, of course, has changed dramatically over the years. So now we have plenty of women who are lawyers as well. And we have men who are legal workers in the organization.
So what are the National Lawyers Guild's primary areas of interest currently?
Well, we have a real breadth of work that we do. It's one of, I think, our strengths politically and organizationally. It is difficult for us because people now get out of law school and they have six-figure debts that they have to pay back. So very often, with very limited money, when they have to decide what organizations to join or not join, they will join organizations that are specific to the work that they're doing because it's more useful to them in some ways professionally to advance their careers. We are much more diverse than that. We have a very successful national immigration project that does work on immigration work. You mentioned the Police Accountability Project, which is a project of the Guild that assists lawyers who represent clients suing police officers or prison officials for violations of constitutional rights. We have a very large labor and employment committee, which is very active in assisting workers, whether union or not, around the country. And as I said, the International Committee is more and more active, which has a number of subcommittees addressing different areas of the world. We have one on Latin America, another one on Palestine. It's doing the Free Palestine Subcommittee, an Africa Subcommittee. We're doing some work with the United Nations. We do that in conjunction very often with the International Association of Democratic Lawyers, which is kind of a international bar organization that is similar in outlook to the Guild, and we're a member of that. And we have a military law task force that's been doing work in support of military resistors for many years. And that breadth and scope of our work is, I think, really important for us because it gives us a perspective that single issue groups do not have, and an ability to sort of integrate the views and the situations that are faced in all of these areas and come up with a more complete analysis of what's going on in the world and how it works. For example, if we talk about immigration, immigration implicates a lot of different other areas that we do work in. First of all, it implicates corporations, because when we talk about immigrants' rights, the transnational corporations, of course, are free to cross borders without any encumbrance. It's only human beings that are affected by immigration laws. It implicates our international work, obviously. It implicates our mass defense work, because if people are going to fight for their rights as immigrants, then they are subjected to repression. The demonstrations in Los Angeles, for example, about 2 years ago, that resulted in that really massive police attack, and actually our mass defense committee was involved, and one of the co-chairs, Carol Sobel, it resulted in, I think, the largest civil settlement in the history of Los Angeles. It implicates, obviously, labor and employment because of the implications to labor with competition between immigrant workers and native workers. So, from my point of view, the fact that we do all of those things creates for us a synergy and an ability to analyze and develop an understanding and to assist people in a way that any group that only concentrates on a particular issue cannot do.
I know the NLG was key in getting together a lot of observers for the WTO ministerial that happened in Seattle in 1999.
Yes, and we've been doing that ever since. That's the work of the Mass Defense Committee. Our legal observer program has been really enormously successful. And we do it in a way that's very different. We've actually now trademarked the name because other people have provided so-called legal observers. But our perspective is very different from what other people have done. We are there on behalf of the demonstrators. We are there on behalf of the protesters. And we consider it our job to make sure that their rights are defended and protected, and to document violations of those rights. We are not there to assist the police in maintaining order. That's their job, and it's their responsibility to do it without violating people's rights. We're not there to act as a go-between or coordinator. We are there representing the people who are demonstrating. And in fact, they are our clients. When we do that. And so we have had real fights over, for instance, turning over film and photographs that our legal observers have taken during demonstrations. Our position is that is work product. That's work that's being done for clients in anticipation of possible litigation, and that therefore is privileged. And a lot of people who have done so-called legal observing are much more willing to cooperate within litigation and even before litigation about that. And the consequence has been we have recovered millions of dollars over the years from demonstrations, the Republican National Committee, the Democratic National Committee demonstrations, the demonstrations in free trade FTAA demonstrations in Florida. I actually think that from the government's point of view, paying those judgments is a cost of doing business. I think that they're quite willing and to violate people's rights. I don't think they care that much about paying those judgments. For example, in Twin Cities, in St. Paul, the Republican National Committee convention, the RNC was required by the city as a condition of hosting the convention to take out, I think it was a $10 million insurance policy in anticipation of litigation as a result of illegal arrest and violation of people's rights. So I think they just planned on doing some of that, and the purpose is to intimidate people, to keep down the numbers of demonstrators by making people actually who are not prepared to engage in work and risk arrest, who do not have a history and have had some practice in this stuff, to make those people who otherwise would come out afraid to do so. And I think it is, it works on some levels, I suppose. Demonstrations are still pretty massive, but I would imagine that there are tens of thousands of people that, but for the fears that are inflicted by that policy, would be demonstrating. And it's our job to make sure that they're able to do that.
Well, speaking of intimidation, on September 24th of this year, the FBI raided multiple homes in Chicago and Minneapolis. Can you talk about that?
Sure. It was actually interesting that they did that over the weekend. We were having our convention in New Orleans. So the lawyers that they would naturally call were by and large in New Orleans at the time. Maybe it was a coincidence. But what they targeted people who were doing solidarity work with Palestine and Colombia, presumably investigating, although grand juries are secret, I'll talk about that a little bit, but presumably investigating what is called providing material support for terrorist organizations. Terrorist organizations are those designated by the Secretary of State as being terrorist organizations, and it's useful to note that the African National Congress was once defined as a terrorist organization, and Nelson Mandela, who is perhaps the greatest political leader of the 20th century, was identified as a terrorist. So the designation is pretty subjective. Anyway, those are the people who were targeted. They were all, from what I understand, members of a pretty small organization. We think that the purpose was it was a small group of a small organization that would not therefore get a lot of support from others. The government was wrong if that was their assessment. And homes were invaded by FBI, computers were seized, documents were seized, things were uprooted, and the individuals were then subpoenaed to come to Chicago to testify at a grand jury there. All of them got guild lawyers, and the government was advised that none of them would be willing to testify. The latest is that the subpoenas have been withdrawn. We don't know for how long, but all of the items seized are still, as far as I know, in the hands of the government, and the government's still going through them. And I note that the Guild back in the 1970s published a book through West Publishing, which is a big legal publisher in the country, on representing clients before grand juries. We have a lot of experience with that. We also formed this coalition to end grand jury abuse back then at a time during the Nixon administration when Guy Goodwin, who was a U.S. attorney that sort of traveled around the country convening grand juries in out-of-the-way places and then subpoenaing people from across the country to go there where they would be away from all their family and friends. And what happens is a grand jury meets in secret. The original idea was so that people who were in the community wrongly accused of having committed crimes no one in the community would know about the accusation until it was looked at by a group of citizens to determine whether or not it was true. So people who were falsely accused did not bear the onus of having been identified prior to their being charged. It was never intended, I don't believe, to be an investigatory tool, but that's how Guy Goodwin used it, and that appears to be what the government was doing in this investigation as well. What they do is they call people before the grand jury, offer them what's called testimonial immunity, which says, we're not going to use your testimony against you in any subsequent prosecution. It doesn't mean that they can't use anybody else's testimony against them for the same matters and issues, and then forces them to testify on pain of contempt of court. And if they're in contempt, they can be put in jail for the life of the grand jury. That's ordinarily 18 months for federal grand juries, and can be extended I think for an additional 18 months in 3-month increments. And people can be kept in jail unless they testify for that length of time. They could also be charged criminally, by the way, for criminal contempt, but that involves an actual trial and the rights that you have and proof beyond a reasonable doubt. Civil contempt is just a judge saying, well, you either testify or you stay in jail because you can get out just by testifying. And it is used, as I say, for investigations, which I think, you watch Law and Order, and they talk about there are two groups. There's the police that investigate crimes and the prosecutors that prosecute crimes. Well, it's the police that are supposed to investigate things and get evidence. It's not up to a prosecutor. The prosecutor's job is to put that evidence together and determine whether or not there's probable cause, and if they find probable cause, to properly present it to a jury to seek a conviction. It's not up to the prosecutor to use this grand jury as a means of investigating and forcing people to testify against their will. Our position is, by the way, it's not simply a matter of a Fifth Amendment privilege against self-incrimination. It's also a First Amendment right of freedom of association. And that right is really impinged upon if you are forced to testify about your friends and associates and the people you work with. So I think from our point of view, we will be defending if they're forced again to testify on both of those issues, both the right of association and the privilege against self-incrimination. The other thing that is really important to understand about all of this is that whether before a grand jury or when we are talking to any police officer, and particularly federal agents, it is unlawful to lie to them. And it's sort of interesting. You watch TV shows, NCIS and stuff, and people seem to willingly go in and talk with, sit down with Agent Gibbs and share with them everything and talk. And it's only when they seem to think that, well, now you're focusing on me as a possible suspect. All of a sudden they say, I want a lawyer. And he says, oh, of course you want a lawyer, because you wouldn't want a lawyer unless you were guilty. And to some extent, that really is sort of what happens to people when they're first approached. Your guard is down. You think that it's okay to say something, and really the only good answer, and I say this knowing that it's much easier to say than to actually do when you're faced with that, and I can tell you that from my own experience. The only good answer is, I don't want to talk to you right now. I need to talk to a lawyer first. And one of the things we were discussing yesterday, it's not a question of saying I'm invoking my privilege against self-incrimination. I'm pleading the Fifth. It's nothing like that. It's like, I need to consult with a lawyer before I talk. And as I was saying, if you say something that's not true and you have no idea what they do know and don't know, you have no idea what they're investigating, and you have to make a decision about whether you can honestly talk. Sometimes they'll tell you what they're investigating, and that makes it a little bit easier. But particularly with these political prosecutions and this sort of stuff about material support, you don't know what they're looking for. You don't know what they know. And answering something by either not being completely truthful or even mistakenly saying something that's untruthful can lead, or not factual, can lead to a prosecution. Martha Stewart was convicted not for anything she did with her corporation. Martha Stewart, with her team of lawyers, was convicted because when she was talking to federal agents, she misstated some facts. And that was what she was prosecuted on.
So I know the National Lawyers Guild, you guys have a website and you have a lot of resources available for people if they want more details on this.
We do. It's nlg.org. We have, and we're about to put out a revised edition of a Know Your Rights leaflet that I think is in PDF, so it can be downloaded. We also have a number of publications, which I believe are also on the website, but can be obtained through the office on some of this history that I've been talking about, particularly around the attacks on First Amendment rights over the last several years by government repression of demonstrations and of demonstrators, the ways in which at these large demonstrations at various and sundry cities across the country, the government has attempted to intimidate and impede for the free exercise of First Amendment rights. It's sort of ironic in many ways that that's going on at the same time that the Supreme Court is now saying that corporations are entitled to all the rights, unrestricted rights of freedom of speech that individuals are supposed to have, but corporations don't get arrested for violating those rights. I don't know why they can't be sort of put on probation and put into receivership for 5 years and made to pay for the supervision or things like that. But we really are, and that's not new, in a country where the rights of corporations seem to be more significant than the rights of human beings.
You've been doing this you've been working on these issues for a long time, 40 plus years. So were you surprised with the Obama administration that it doesn't really appear that things have changed much?
No. First of all, my experience has been over the years that any time the executive gets more authority, the next president is completely unwilling to give it up. I know Clinton, for instance, invoked many of these issues of executive privilege that had been raised by the first Bush administration that everyone was appalled about when he raised it. And that, I think, is just sort of a natural progression. Beyond that, the Obama administration has from the start taken these positions on questions of so-called national security, on questions of government secrecy, has been in lockstep with the Bush administration. The Guild has worked on the Al-Haramain case out in California, which was a Muslim charity that was infiltrated by the government. It was exposed to have been done so illegally, and the position that was taken, both when it was being litigated during the Bush administration and then after Obama came in, was the court can't even consider this, that this is a matter of national security, and you just got the judge, you got to take us on faith that we can't expose any of this stuff, we can't discuss it, and it can't be part of the record. So from the beginning, and the lawyers were told this came from the top levels of the Justice Department, from the beginning on those issues, regardless of what other differences there have been, on those issues, the Obama administration has been absolutely no different from the Bush administration, other than the fact that it chooses to engage in illegal war in Afghanistan and Pakistan rather than engaging in illegal war in Iraq, if removing all but 50,000 troops and probably an equal number of mercenaries it constitutes not engaging in war in Iraq.
All right. Well, unfortunately, with that, we are out of time. I want to thank you very much for coming and spending time with us this morning.
Thank you for inviting me. It was a pleasure.